The Senate will come to order. Senator Merrifield.
Members and guests, please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Majors, please call the roll.
Senators Aguilar, Baumgartner, Carroll, Cook, Crowder,
Absent.
Donovan, Garcia, Grantham, Guzman, Heath, Hill, Hodge, Holbert, John, Johnston, Jones, Kafalas, Kerr, Lambert, Lundberg, Marble, Martinez-Umenick, Merrifield, Neville, Newell, Roberts, Scheffel, Scott, Sonnenberg, Stedman, Tate, Todd, Ulibarri,
Absent.
Woods, Crowder,
We kind of need to know before roll call.
Well, we gave the information before
We did?
last Friday.
Oh, from last Friday?
We gave it.
Ulibarri.
Excused.
Mr. President,
Here. With 34 present, 0 absent, 1 excused, we have a quorum. Senator Woods.
Thank you, Mr. President. I move that the journal from Friday, February 19th be dispensed with and be approved as corrected by the Secretary.
You have heard the motion. All those in favor say aye. Aye. Opposed, no. The ayes have it. The motion is adopted and the journal is approved. Senate Services.
February 22nd, 2016, quickly engross Senate Bill 70, 79, and 88, Senate Joint Resolutions 8 and 9, Senate Joint Memorial 1, correctly re-engross Senate Bill 121, correctly revised House Bills 1053 and 1069, correctly re-revised House Bills 1237, 1238, 1239, 1242, 1243, 1244, 1245, 1246, 1248, 1249, 1250, 1251, 1252, 1253, and 1254.
Third reading of bills consent calendar. Mr. Majors, would you please read the title of all the bills on the third reading of bills consent calendar?
House Bill 1053 by Representative Kraft, Harper, Senator Hill, concerning the regulation of retail hydrogen fuel systems for vehicles. House Bill 1069 by Representatives Rankin and Moreno, Senator Grantham, concerning the ability of a city's governing body to determine the length of terms for its housing authority commissioners.
Majority Leader Scheffel.
Thank you, Mr. President. I move that the Senate adopt the bills listed on the third reading of bills for final passage consent calendar, which includes House Bill 1053 and House Bill 1069.
You have heard the motion. Is there further discussion on any of the bills on the third reading of bills consent calendar? Are there any no votes on either of those bills? With 34 ayes, 0 no, 0 absent, 1 excused, House Bill 1053 is adopted. Co-sponsors. Senator Todd. Senator Crowder. With 34 ayes, 0 noes, 0 absent, 1 excused, House Bill 1069 is adopted. Co-sponsors: Senator Kafalis, Senator Crowder, third reading of bills, final passage. Mr. Majors, would you please read the title to House Bill 1240?
House Bill 1240 by Representative Hamner, Senator Lambert, considering a supplemental appropriation in the Department of Healthcare Policy and Financing.
Majority Leader Scheffel.
Thank you, Mr. President. I move that the Senate lay over House Bill 1240 to February 23.
The motion is to lay over House Bill 1240 until February 23rd. All those in favor say aye. Aye. Opposed, no. The ayes have it. House Bill 1240 will lay over until February 23rd. Mr. Majors, would you please read the title to Senate Bill 79?
Senate Bill 79 by Senator Todd and Representative Young, concerning increasing the alignment of post-secondary workforce readiness initiatives at the secondary education level with post-secondary career and technical education.
Senator Todd. Senator Todd.
Thank you, Mr. President. Good morning, colleagues. I move Senate Bill 79 on third reading and final passage and ask for an aye vote.
Is there further discussion? Seeing none, the motion before the body is the adoption of Senate Bill 79 on third reading and final passage. Are there any no votes? Senator Marble? Senator Lundberg? Senator Lambert? Senator Neville? Senator Baumgardner? Senator Scott? With 28 ayes, 6 noes, 0 absent, 1 excused, Senate Bill 79 is adopted. Co-sponsors: Minority Leader Guzman, Senator Stedman, Senator Heath, Senator Kafalis, Senator Jones, Senator Kerr, Senator Hodge, Senator Aguilar, Senator Johnston, Senator Donovan, Senator Newell, Senator Hill, Mr. Majors, would you please read the title to Senate Bill 88?
Senate Bill 88 by Senator Stedman and Representative Willett, concerning the revised Uniform Fiduciary Access to Digital Assets Act.
Senator Stedman.
Thank you, Mr. President, and good morning. I move Senate Bill 38 on third reading and final passage.
You have heard the motion. Is there further discussion? Seeing none, are there any no votes? With 34 ayes, 0 noes, 0 absent, 1 excused, Senate Bill 88 is adopted. Co-sponsors: Senator Newell, colleagues, let me remind you that if for some reason You don't get added as a co-sponsor. You can let the desk know anytime before it's sent to the House. Mr. Majors, would you please read the title of Senate Bill 70?
Senate Bill 70 by Senator Neville and Representative Everett concerning the prohibition of discrimination against employees based on labor union participation.
Senator Neville.
Thank you, Mr. President. I move Senate Bill 70 and ask for permission for a third reading amendment.
Please explain the request for permission.
Colleagues, we had some extensive debate regarding this passage here on page 3, lines 9 through 18, and we haven't been able to gain agreement here on what this actually does, but it does utilize card check language, which is definitely not the focus or the emphasis of the bill.
The motion before us is to grant Senator Neville permission to offer a third reading amendment. All those in favor say aye.
Aye.
Opposed, no. Permission granted. Senator Neville.
Thank you, Mr. President. I move L013. It basically strikes out from the engrossed bill lines 9 through 18 and ask for a favorable vote.
Is there further discussion? Senator Jones. Senator Heath.
Thank you, Mr. President. This bill is very important. I'd love to ask for a senatorial 5 so we have time to read this and see what it does.
The Senate will be in a senatorial 5. Recess is over. The Senate will come back to order. Senator Jones.
Thank you, Mr. President. Members, what this amendment does is strikes the amendment that we made yesterday. And I'll read it to you. This is what we're striking. On or after the effective date of the section, an employer shall not discriminate against an employee whose cards are being circulated during collective bargaining or while a labor election is pending by. So by voting yes on this amendment, you're implying that it's okay to discriminate based on applying a physical restraint. It's okay to restrain physically people. It's okay to prevent bathroom use. People can't go to the bathroom. You're voting against people going to the bathroom, folks. Eliminating lunch breaks, reducing pay. This is all retaliatory stuff that has happened. I asked for a no vote because a yes vote to make this change says it's okay to apply physical restraint, prevent bathroom use, eliminate lunch breaks, reduce pay, and demote the employee. Really bad idea. I ask for a no vote.
Senator Neville.
Thank you, Mr. President. I think when we had this discussion on Friday that it was pointed out that all of these issues are already covered under various statutes and various protections for our employees. So I don't think we're going to be stopping anybody from going to the bathroom or anything else. So again, I encourage an aye vote.
Is there further discussion? Senator Stedman.
Thank you, Mr. President. And colleagues, I'd like to just rise for a moment and talk about the procedural posture we're in considering third reading amendments. It has been a long-standing tradition of the Senate that we will offer permission to our colleagues to amend bills on third reading. The Senate is far more lenient with this proceeding than the House, which is far more rigid, of course. But here we are considering a third reading amendment on a bill that's still in the first House, that will still have another chamber to go through for errors to be corrected. Here we are considering a third reading amendment that is a third bite at the apple, really, because when we debated this bill on the floor on Friday, we put on an amendment that inserted this language. We then adopted another amendment that deleted half of that amendment, and we called it good. And now here we are on Monday coming back for a third bite at the apple to delete all of the original amendment in its entirety. Wherever the little flipper, the porpoise is, it's going to be busy today because we're really taking, a full retreat from votes that we took on Friday and amendments we put into the bill at that time through a procedural posture of being on third reading on a bill that's still in the first chamber. So I, Mr. President, will be voting no on the amendment. I liked what we did with the floor amendment on Friday, and it's unfortunate that we're coming back to negate the rest of it today.
Mr. President.
Thank you, Madam President. Well, no good deed goes unpunished here. I saw an amendment Friday that I thought spoke volumes about what we should consider on this legislation. And I supported it. Not only did I support it, I rallied the troops to support it as well. We believe that the contentious issues that were purported by that amendment should have been addressed, and they were. But there were things in that amendment that were wrong. There were things in that amendment that struck out the very bill that we were sponsoring, that we were supporting. What was highlighted later in that debate about that amendment was the fact that we had a kumbaya moment, and now the kumbaya is gone and the family reunion was going to break up. I'm not going to use the word nefarious, because that would be inappropriate. But I will tell you that some of that amendment which said strike a line or strike a page was specifically designed to gut the power of this bill. And with that, the bait of that amendment were things that we supported. The bait of that amendment were the things that we still support. We had an amendment to correct that in the committee of the whole. We didn't catch it all until the weekend, and now we have. That's part of the process. Congratulations. Perhaps the lesson here is to just say no in the future. If you've got a good idea and you're burying it in a bunch of bad ideas, why don't you keep your amendments and save some time? Is there further discussion? Senator Carroll.
Thank you, Mr. President. I also am getting up to speak against L013. This takes us back to a posture where none of the bipartisan input or feedback will have been accepted on this bill by the time L013 would pass. And it represents the core of where I think we, in fact, did find common ground, that there is absolutely no straight-faced justification or excuse for discriminating against employees by using, during a collective bargaining process, by using things such as physical restraint, prohibiting access to bathroom use, eliminating lunch breaks, retaliating by reduction of pay, demoting, and so forth for an employee. We actually all agreed that those are so outrageous. I think 35 of us would agree that that shouldn't happen. And that is the core, I think, of where there was agreement. And so L013 obviously pulls that out of the bill. I have heard it stated that somebody, well, the sponsor thinks that these things are prohibited under current law. And I would just say, if you think that is the case, there is no reason to run this amendment, because under that theory, at most, it would be clarifying and redundant. So if you believe these are intolerable and unjustifiable behaviors, whether...
Is there further discussion? Seeing none, are there any no votes? Minority Leader Guzman, Senator Merrifield, Senator Jones, Senator Heath, Senator Kerr, Senator Carroll, Senator John, Senator Johnston, Senator Aguilar, Senator Kafalis, Senator Todd, Senator Donovan, Senator Newell, Senator Garcia, Senator Stedman, Senator Hodge. With 18 ayes, 16 noes, 0 absent, 1 excused, the amendment is adopted. To the bill, Senator Neville.
Thank you, Mr. President. Thank you, colleagues. I urge an aye vote on Senate Bill 70.
Senator Heath.
Thank you, Mr. President. I happen to think this is one of the most important bills that we will be considering this session. So forgive me for coming up on third reading, which I ordinarily don't do and we don't do, but I felt I needed to do this. I think, as most of you know, I served on the Denver Chamber Board for a long time, chaired the Economic Development Committee for twice, and served on it for a long time as well, and have been involved through the Chamber and through my own personal work in recruiting companies to this state for many, many years. And as a result, you can't be involved in that without talking about labor in this state and how labor works vis-a-vis business. So Friday afternoon, I called my good friend, our good friend Tom Clark, who heads up the Metro Denver Economic Development Corporation, and I served when that group was first put together. And when I talked to Tom, I found out that he had actually written something on the state labor status of 2015. He wrote this in September of 2015. And I'm just going to read parts of this to you. We have, as I alluded to on Friday, a modified right-to-work state. The Colorado Labor Peace Act of 1943 put in this modified right-to-work state, and it has survived and basically treated us well ever since 1943. A long time, some 62, 63 years, as a matter of fact. We took a crack at a union state in 2007. Actually, this legislature passed it. It was vetoed by Governor Ritter. And then we had a ballot measure in 2008 to put us in a right-to-work status, and that was defeated. So at all levels, the Colorado Labor Peace Act has survived for many reasons, but not the least of which it has been very, very successful and has served us well. And this bill would basically destroy the Colorado Labor Peace Act. Tom, in the summary on the first page of his state labor status report of 2015, he talked about the modified right-to-work status, and this is just the summary. From 2008 to 2014, Colorado's job growth was nearly 6 times that of unionized states and 2 times that of right-to-work states. Wage growth in Colorado was slightly higher in unionized states during 2008 and 14 and substantially higher than right-to-work states. And we've talked about the need to increase wages for middle-class Americans here over and over and over again. And his conclusion was Colorado's progressive labor law promotes productive relationships with unions without abolishing them. In his summary, he states, our conclusion is that the Colorado Labor Peace Act is the best union labor law in the nation. The best union labor law in the nation. We performed, again, the same analysis, he said, this past summer, examining Colorado's job growth and wages during the Great Recession. Once again, the data did not disappoint. This is Tom Clark speaking. I'm quoting from Tom Clark's letter. Colorado outperformed union shop states by 600% in job creation and double that of right-to-work states. And wage increases in Colorado beat both union shops and right-to-work states. So from every standpoint, whether you're a union state or a right-to-work state, Colorado did better. And this I thought was interesting. This is Tom again, because this is directed at consultants who basically are looking at where to relocate companies. That's what this is all about. Consultants looking to relocate companies to Colorado, and basically Tom saying our conclusion is the Colorado Labor Peace Act is the best union labor law in the nation. And it concludes, the consultants were surprised to learn of the Colorado Labor Peace Act of Colorado has a showpiece labor relations law, and these consultants said they suggest it's time for us in Colorado to shout it to the mountaintops. Colleagues, we have, by all accounts, the best labor law in the country through the Colorado Labor Peace Act of 1943. It, like anything that tends to work, it was a compromise. It was a compromise between business and labor. And that compromise has served us very well for 60-plus years. So why would this body, at this crucial time, want to destroy that and create something that we know doesn't work nearly as well? I would ask strongly for a no vote.
Is there further discussion? Senator Kerr.
Thank you, Mr. President, and I'm very glad you called on me because actually I was just raising my hand to go to the bathroom after that amendment passed. But since I'm up here anyways, I'll go ahead and bring up a couple of points that we discussed on Friday. You know, on Friday, we've already talked about this a little bit on the amendment that just passed, but on Friday there was an amendment that was passed following the rules of the Senate. It was passed by a unanimous vote of this chamber, and then was partially undone through a divided vote of this chamber, and then on Friday, and then today was completely undone this morning, just a few minutes ago. So that's where the bill stands right now. So I want to go back to a list that the sponsor of this bill read to us on Friday, and it was a list of states that have right to work for less. And it was a great list of states. It included states like Alabama and Mississippi. I know states that we're all striving, Colorado, we want our economy to be like the economies of Alabama and Mississippi, I suppose. But the state I want to mention off that list was actually highlighted by the sponsor of this bill. And that was, he highlighted that it was the most recent example of a state that had passed this kind of legislation. So you would think that the fact that this state being highlighted as the most recent state would probably be the best example, be an example that we all want to strive for. And of course, that state was Wisconsin. And Wisconsin passed this legislation in 2011. In the next 12 to 18 months, the state of Wisconsin saw one of the most divisive political experiences that any state has experienced in the last century. And we all remember that very clearly. We remember very clearly that members of the Senate, of the Wisconsin Senate, were put to recall. Yes, I'm going to use that word here. Were put to recall. The governor himself was put to recall. And there were various outcomes. Some of the senators were successfully recalled. The governor was not. But my point here is this very subject, this legislation, led to such a divisive time in the state of Wisconsin. And then again on Friday, we found an agreement. We found an agreement between Democrats and Republicans. We found an agreement between proponents and opponents of this bill. And together, we pulled together. I feel like we have learned some lessons in this body and other bodies around divisive legislation. But obviously, the lessons we haven't learned, that unanimous agreement on an amendment in this body was partially struck down on Friday afterwards and then completely struck down today. Again, I ask, can we not go back? Can we not go back to that moment last week when 35 of us came together, seemed to have learned the lessons of divisive topics in the past, and came together to agree on legislation? Can we not do that? It seems as if we can't. Now is the time for all of us to stand up, work across the aisle, and remember that moment when we actually worked together, we actually had agreement. Let's end the divisiveness. Let's end the chasm that this aisle sometimes affords, and see if we can't go back to that moment. Please vote no on Senate Bill 70.
Minority Leader Guzman.
Thank you, Mr. President. Colleagues, this is a very important time, as we all know. Colleagues on this side, you have the vote. You've earned the majority. And so you will pass this bill. But our colleagues on this side of the room will never waver in supporting the rights of our workers here in Colorado. Our voice has been and will remain firm. We will not waver. We played a very good political role this week in the work towards the amendments that were brought. You've heard recently through one of our members that a major business agency in this state sees the Colorado Labor Peace Act as one of the finest in the nation, benefiting business. So we're proud to stand and continue to stand and respect dignity and rights of our workers. The vote is yours. The win is going to be ours.
Senator Lundberg.
Thank you, Mr. President. Mr. President, I've not engaged in the debate on the floor on this issue up to this point, but right before the vote, I'd like to say a couple of things. One of which is there was a note that in Wisconsin there was a very, very difficult political battle that occurred, and I won't deny that. But I'll also note that you need to go back and look and see how Wisconsin is doing as a right-to-work state, and how the state government is able to actually balance their budget in some respects that they were incapable prior to that. That's one of the reasons I stand up here in support of this bill. And secondly, I want to correct the record on just what this bill is all about. This bill is to defend the right of every citizen in the state of Colorado to associate with those organizations that they wish to and not be held hostage by their employment. That's what right to work means. It means the individual worker has the right to work in any employment without being forced to either join a union or materially support that union to the extent that they have joined that union. I believe this is a freedom issue, and I believe this is an economic issue. This is one of those dividing lines that there will always be quite a bit of political energy and political debate, because it does strike to a key issue within our economic system. But as I understand it, right to work, and I'm grateful that Colorado is not fully union state, but to call it a modified right to work state misses the mark. I'd say it's a modified union state. If there is a descriptor to be added to the Colorado law. I very proudly vote for this bill because it is a bill that, if it became law in the state of Colorado, the people of Colorado would have more freedom and the economy of Colorado would prosper, and therefore the citizens of this state would have a greater prosperity, greater freedom. I don't see a losing scenario in this mix.
Is there further discussion? Seeing none, the motion before the body is the adoption of Senate Bill 70 on third reading and final passage. Are there any no votes? Minority Leader Guzman. Senator Heath. Senator Hodge. Senator John. Senator Stedman. Senator Carroll. Senator Newell. Senator Todd. Senator Merrifield. Senator Garcia. Senator Donovan. Senator Johnston. Senator Jones. Senator Kafalis. Senator Kerr. Senator Aguilar. With 18 ayes, 16 noes, 0 absent, 1 excused, Senate Bill 70 is adopted. Co-sponsors. Majority Leader Scheffel, Senator Scott, Senator Lundberg, Senator Cook, Senator Baumgardner, Senator Grantham, Senator Roberts, Senator Hill, Senator Marble, Senator Lambert, Senator Sonnenberg. General Orders, second reading of bills. Senator Woods? Got to work your way up.
Good morning, President Cadman. Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for the consideration of the General Orders second reading of bills consent calendar.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The Senate will resolve itself in the Committee of the Whole for the consideration of General Orders second reading of bills consent calendar. Senator Woods will take the chair.
The committee will come to order. The coat rule is relaxed. Mr. Majors, would you please read the title to the bill listed on the consent calendar?
Senate Bill 110 by Senator Woods, Representative Lundin, concerning protecting the privacy of child victims when releasing criminal justice records.
Majority Leader Scheffel.
Thank you, Madam Chairman. I move that the committee adopt the bill listed on the General Order second reading of bills consent calendar, which includes one bill, Senate Bill 110, and its associated Judiciary Committee report. Ask for an aye vote.
Is there any discussion on the committee report? The motion before the body is the adoption of the report on the bill on the consent calendar, second reading consent calendar. All those in favor say aye. Opposed, no. The ayes have it. The report is adopted. Is there any discussion on any of the bills listed on the consent calendar? Seeing none. The motion before the body is the adoption of the bill on the General Order second reading of bills consent calendar. All in favor say aye. Opposed, no. The ayes have it, and the bill is adopted. Majority Leader Scheffel.
Madam Chair, I move the committee rise and report.
All those in favor of rising and reporting say aye. Opposed, no. The ayes have it. The committee will rise and report.
Effie, can you hand this to her? I'm sure you'll be back. The Senate will come back to order. Senator Woods.
Thank you, Mr. President. The committee has met and had one bill under consideration. Mr. Majors, would you please read the report?
February 22nd, 2016, Mr. President, the Committee of the Whole brings the reports under consideration with the following task bill being second reading thereof makes following recommendations thereon. Senate Bill 110 is amended, passed on second reading, in order and gross, placed on the counter for third reading and final passage.
Senator Woods.
Thank you, Mr. President. I move for the adoption of the report.
You have heard the motion. Is there further discussion? Seeing none, are there any no votes? With 34 ayes, 0 noes, 0 absent, 1 excused, the report of the Committee of the Whole is adopted. Senate Bill 110, as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. General Orders, second reading of bills. Senator Woods.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for the consideration of General Orders, second reading of bills.
You've heard the motion. All those in favor say aye. Those opposed, no. The ayes have it. The Senate will resolve itself into the Committee of the Whole for the consideration of General Orders, second reading of bills. Senator Woods will take the chair.
The committee will come to order. The coat rule is relaxed. Mr. Majors, would you please read the title to Senate Bill 34?
Senate Bill 34 by Senator Sonnenberg concerning tampering with a deceased human body.
Senator Sonnenberg.
Thank you, Madam Chair. I move Senate Bill 34, and I do have an amendment.
To the amendment, Senator Sonnenberg.
Thank you, Madam Chair. Just got these as I walked into the chamber this morning, so thank you. I move L006. I guess I need to do that first, Madam Chair.
There is an amendment on the desk. Mr. Majors, would you please read Amendment L006?
Amendment L006, Senate Bill 34 by Senator Sonnenberg, amendment printed bill page 3, strike lines 2 through 14, substitute 2A, except as provided in paragraph B of this subsection 2, tampering with a deceased human body is a class 5 felony. Subparagraph B, tampering with a deceased human body is, paragraph 1, a class 3 felony in the human body, part of a human body or human remains are related to a charge of a class 1 felony or class 2 felony, or 2, a class 4 felony if the human body, part of a human body or human remains are related to a charge of a class 3 felony or a class 4 felony.
Senator Sonnenberg.
Thank you, Madam Chair. I move L006.
Is there any discussion on Amendment L006? Senator Sonnenberg.
Thank you, Madam Chair. What L006 does, and I heard your conversation and I appreciate it. If you remember, the conversation was that if there was no charge to the original crime, that there indeed then would not be able to have a charge with the tampering crime. And so working with the DAs and the drafter, what it does, it leaves the sliding scale in place, but then puts a class 5 felony for anything that's not charged. I guess that's less than what it was asked. At one point we were talking class 2 felony. That seemed a little harsh, and so I think this is a reasonable compromise. Ask for your yes vote.
Senator Stedman.
Thank you, Madam Chair. And colleagues, if you'll recall our discussion on this bill last week, I was the one that pointed out what I saw as a loophole in the law by saying that all of the penalties were contingent upon how the underlying homicide was charged. And Amendment L006 fixes that problem in part. But I want to explain to you what the flaws are in 006 and how this isn't necessarily still going to accomplish what folks are hoping it accomplishes. 006 sets out as a baseline that tampering with a deceased human body is a class 5 felony. So that at minimum, you're going to get a class 5 felony. And then it goes on to say that if the remains are related to a charge of a class 1 or 2 felony, then we're going to bump up the penalty on tampering. We're going to bump it clear up to a class 3. If the tampering is with remains related to a class 3 or class 4 felony, we're going to bump that also to a class 4. So you've got a sentencing structure here where you've got a baseline offense where it's a class 5 felony at minimum, and the opportunity to enhance that punishment under certain circumstances that, again, may never happen if no one is charged. And so, yes, we fixed the problem in that we have a penalty that will apply across the board for everyone, but the amendment's attempt to create enhanced penalties based upon the nature of the homicide that produced the dead body, it fails. It fails to do that because it's still dependent upon someone actually being caught and charged before the person who tampered with the dead body could experience the enhanced penalty. I still think this is really not the right way to write this law, but at least it fixes the larger half of the problem that I raised last week. Let me tell you another reason why I don't like this approach. I believe that this law, it would be susceptible to constitutional challenge under the equal protection arguments. And remember, from our discussion of the bill last week, we are carving out of the existing crime of tampering with evidence, tampering with deceased human bodies. So this bill, Senate Bill 34, becomes the only way to punish tampering with a deceased human body, whereas today we have the more universal, generic crime of tampering with evidence. So we're putting all our eggs in this basket, and it's not really doing everything it's being promoted to do, but we're also creating an equal protection problem where, think of it this way. Let's say suspect number 1 and suspect number 2 both come across a dead human body and decide to tamper with the evidence and try to conceal it. And they both had exact same intentions. They both took the exact same illegal actions. And yet, in one case, they're going to be prosecuted with a Class 5 felony. In another case, it turns out that the body they tampered with was murdered. It was the victim of a Class 1 felony. And so the DA tries to do the enhancement here where defendant number 2 gets charged with a Class 3. You have identical defendants engaging in identical conduct with identical mental state or mens rea as to what is the nature of their guilty act and what are they intending. And you have a statutory scheme that provides 2 different possible punishments. That, colleagues, violates the Equal Protection Clause and was another reason why the penalty enhancement portions of this amendment are not going to fly, are not going to accomplish what you want to accomplish. But, you know, you've fixed the baseline, you've created a Class 5 felony, so if you insist on treating this separately, know that that's what you've done. And I still think this bill has problems and probably needs to go back to the drawing board. I'm going to be voting no.
Is there any further discussion on Amendment 6? Senator Sonnenberg.
Thank you, Madam Chair. Can I ask for a senatorial 5?
Granted. Leader shuffle. The Senate will come back to order. Majority Leader shuffle. The Senate committee. The committee will come back to order. Majority Leader shuffle.
Thank you, Madam Chair of the Committee of the Whole. Move that Senate Bill 34 lay over to the end of the general order, second reading of Bill's calendar.
The motion before the body is to lay over Senate Bill 34 to the end of the general order, second reading calendar. All those in favor say aye. Aye. Opposed, no. The ayes have it. This bill will be laid over until the end of the second reading of Bill's general orders calendar. Mr. Majors, would you please read the title of Senate Bill 17?
Senate Bill 17 by Senator Neville and Representative Neville concerning allowing a law-abiding person to carry a concealed handgun without a permit in connection therewith preserving current laws restricting the carrying of concealed handguns on certain property, including school grounds.
Majority Leader Shuffle.
Thank you, Madam Chair. I move the committee lay over Senate Bill 17 to follow Senate Bill 48.
The motion before the body is to lay over Senate Bill 17 to follow Senate Bill 48 on the general order's second reading of Bill's calendar. All those in favor say aye. Aye. Opposed, no. The ayes have it. Senate Bill 17 will be laid over to follow Senate Bill 48. Mr. Majors, would you please read the title to Senate Bill 48?
Senate Bill 48 by Senator Marble and Representative St. Salvador concerning requiring federal regulatory agencies to provide notice before using special units to conduct operations within the state.
Senator Marble.
Thank you, Madam Chair. I move Senate Bill 48.
To the bill, Senator Marble.
Thank you, Madam Chair. Senate Bill 48 is pretty straightforward. There's nothing in here that's a trick, but only protection. It is a good bipartisan bill that has support in the House and Senate. I would like to say that this bill is also supported by the national hemp growers and so many of our marijuana industry people. There are a lot of concerns concerning the fact that we are operating outside of federal law within the state of Colorado in growing hemp and marijuana. And what we are looking for is not to tell the federal regulatory agencies that they cannot conduct their administrative duties, but only that before they deploy one of their SWAT units or SET teams, that they give a 24-hour notice to our local law enforcement to ensure the protection of the people within the state of Colorado.
Is there any further discussion on Senate Bill 48? Senator Carroll.
Thank you, Madam Chair. I like the idea of notice. My only question is, how do we, what is the enforcement? Let's say in a situation that's described like this, that the federal agency does not provide 24 hours notice, what happens?
Senator Marble.
Thank you, Madam Chair. And that has been a question that has been brought up several times. What do we do when we have marijuana and hemp industry people investigated and brought to federal courts over this? What is that retaliation when we have given them permission? Actually, this bill is asking for the professional courtesy, the courtesy that should exist across the board in all agencies, but unfortunately does not. So with a type of some sort of what you're looking at, how are we going to punish them if they don't give the 24-hour, what recourse do we have? At this point, it would be that we are just stating the fact that professional courtesy, give us the 24-hour notice, but there is no backlash with this bill. It is just more of a request and to put them on notice that we do take our citizens and their safety in their operations in industries that are operating outside the federal law very seriously.
Is there any further discussion on Senate Bill 48? The motion before the body is the adoption of Senate Bill 48. All those in favor say aye. Aye. All those opposed, no. The ayes have it, and the bill is passed. Mr. Majors, would you please read the title to Senate Bill 17?
Senate Bill 17 by Senator Neville and Representative Neville concerning allowing a law-abiding person to carry a concealed handgun without a permit in connection there preserving current laws
Senator
restricting
Neville.
carrying of concealed handguns on certain property, including
Thank you,
school
Madam Chair.
grounds.
I move Senate Bill 17 and ask for a favorable vote.
The motion before the body, is there discussion on Senate Bill 17? Senator Neville.
Thank you, Madam Chair. Folks, no doubt we've had strong debates surrounding the Second Amendment. That debate is going on now. It will for years to come. In many ways, tragedy has struck our great state more than any other when it comes to the loss of innocent life. As a parent who had a child at Columbine and saw the impact up close that that tragedy had on Columbine, I'm very familiar with this. Yet after each tragedy, our legislature has worked to legislate the problem with more restrictions on our constitutional right to keep and bear arms. Members, the restrictions were wrong then, and they're wrong now. This bill restores those rights. Furthermore, we've heard the facts. States with this legislation in place haven't seen more crime, and in most cases, they've seen less crime. Criminals are less likely to create havoc when they know there is a possibility that any honest, law-abiding citizen at any time and any place can thwart their evil plan. Just look at the situation we saw at New Life Church in Colorado Springs. But when it comes to the preservation of liberty and our constitutional rights, it's every law-abiding citizen's right to keep and bear arms, and the Second Amendment is the bulwark against tyranny. Constitutional carry restores those inalienable rights to law-abiding citizens. Members, I'm asking for you to stand for liberty today by protecting the right for honest, law-abiding citizens to carry a firearm to protect themselves without having to beg for government permission. I'm asking for you to join with me in supporting this bill. I'm asking for you to join with me in upholding the oath each one of us made to protect the Constitution. Because at the end of the day, it's my prayer that we all take that oath seriously. Thank you, and I ask for an aye vote.
Is there any further discussion? Senator Jones.
Thank you, Madam Chair. Well, third time on this bill on second reading. Maybe we'll get done today. The other day, the majority leader said great. The other day, we talked about how you had to do a background check. And I brought up that felons can't get these. It's a reason to not get this. And it was said, well, they shouldn't even have a gun. Well, yeah. Then why wouldn't you check it? Then you could find out the felons who have guns, and then you could prosecute. So that's it, but that's not the only reason. If they've been convicted of perjury, don't you think people who've been convicted of perjury shouldn't have a concealed carry permit? Somebody who's chronically or habitually used alcoholic beverages, controlled substances, a protective order. Somebody who shouldn't be around other people. That's why they do concealed carry permits, to find those people. But that's not all. There's the training aspect that this would eliminate for people. It's a pretty bare bones training aspect already, and something we should fix, in my opinion. But we just heard about how these are all law-abiding citizens that will make us safer. And to that, I'd like to offer amendment, I move 006.
There is an amendment on the desk. Mr. Majors, would you please read Amendment 6?
Amendment L 006, Senate Bill 17 by Senator Jones, amendment printed bill page 3 after line 19, insert section 3 in Colorado Revised Statutes, add 13, Tech 21, Tech 129 as follows. 1321-129, strict liability for damages, concealed handguns. A person who carries a concealed handgun despite not possessing a permit to carry a concealed handgun issued pursuant to Part 2 of Article 12 of Title 18 CRS is strictly liable for any injuries or death resulting from any use of the handgun. Renumber succeeding sections accordingly.
Senator Jones.
Thank you, Mr. Chair. Well, Max is pretty fast. I don't know if you heard that. Strict liability for damages concealed handguns. It says it is strict if you have a concealed carry weapon without a permit, you are strictly liable for any injuries or death resulting from any use of the handgun. This makes us safer, right? Well, if it makes us safer, you would vote for this, because then people are responsible. These are law-abiding citizens. This ensures that they're responsible for their actions for doing this. And if you think they're safer, you would vote for this.
Senator Holbert.
Thank you, Madam Chair. I rise in opposition of L006. As we discussed on second reading, a concealed carry permit would not protect a permit holder from such liability. This is one of the great myths of having a concealed carry permit. You have no right, no opportunity to cause damage. You have to keep it concealed. Even having it imprinting through your clothing would be a violation of that permit. There is no protection for liability for a permit holder. This is not necessary because if anyone, whether they have a permit or not, creates some damage, harm, something for which they would be liable, they are. So this myth that exists about a concealed carry permit, that it allows some protection under the law for anything greater than having your coat on or a sweatshirt or some other article of clothing that would keep it hidden, that's a myth. It doesn't create. There's nothing in statute now, there's nothing on the concealed carry permit application, there's nothing that a sheriff approves that gives a concealed carry permit holder some greater protection under the law other than that Class 3 misdemeanor of carrying a handgun without a permit, which is a very small fine and possibly up to 2 weeks in jail, which doesn't happen because if a person is carrying concealed with or without a permit and does nothing wrong, i.e. create liability, no one would ever know that they actually have that weapon. And whether or not they have a permit, if they pull that weapon out and cause some harm for which there would be liability, the permit offers them no protection. This is truly a straw man argument and ask for a no vote.
Is there any further discussion on Amendment 6? Senator Jones.
Thank you, Madam Chair. Well, I'm not a straw man, not that I know of. This is true. This is in black and white, putting it down that if you don't have a concealed carry permit and something happens, you leave that weapon in a room or something like that and it discharges and hurts somebody, you're responsible. These are responsible, law-abiding citizens, it's been said. And the other thing is that it's been said that this makes us safer. And if you believe it makes us safer, you would vote for this amendment. I ask for yes votes.
Senator Neville.
Thank you, Madam Chair. Friends, I ask for a no vote on L006. The idea of whether you have a permit or don't have a permit does not change your responsibility under the laws and statutes of Colorado for responsible handgun ownership. Nothing changes there. This is basically a way of trying to, I'm not sure what it's trying to do, but create some kind of a higher standard to possibly darken the law and darken those people who want to actually exercise constitutional carry. I urge a no vote.
Is there any further discussion on L006? Seeing none, the motion before the body is the adoption of Amendment L006. All those in favor say aye. Aye. Those opposed, no? No. The noes have it and the amendment fails. Senator Jones.
So what I found interesting about, thank you, Madam Chair, what I found interesting about this bill in committee and on the floor is that right now, it was the other day, somebody came up here and said, the training really doesn't matter, it's only 3 hours anyway. And I thought to myself, that's probably not good enough. And the other thing we had in committee, the witness came and said, I got my concealed carry permit, and we weren't required to go out to the live fire range to actually practice with this weapon to demonstrate our competency. But I signed up for that part of it anyway. I went out, and the instructor spent most of their time trying to not have somebody point a weapon at them. These are people with no firearms experience in some cases, and we're saying you can have a permit, but now we're saying you don't even need that. You don't even need to have a class or training. So with that, I move L007.
There is an amendment on the desk. Mr. Majors, would you please read Amendment L007?
Amendment L007, Senate Bill 17.
Senator Jones.
Thank you, Mr. Chair. Members, what this does is says, look, you got to not have 3 hours of training, you have to have 8 hours, and of that, 2 of them have to be in a live fire situation to demonstrate your competency, so we're not giving permits, concealed permits, without adequate training. 3 hours isn't enough. It was dismissed the other day in one person's comments at this mic. It's only 3 hours. Well, let's make it 8. Let's make it real. This is something we can agree on. So I ask for a yes vote.
Senator Neville.
Thank you, Madam Chair. The purpose of this bill, friends, is to allow people to exercise their constitutional right with less restriction, not with more restriction. This amendment goes exactly in the face of that, requiring more restrictions before you can exercise your God-given, inalienable right to keep and bear arms. I urge a no vote.
Is there any further discussion on Amendment L007? Seeing none, the motion before the body is the adoption of Amendment L007. All those in favor say aye. Aye. Opposed, no? No. The noes have it, and the amendment fails. Any further discussion on Senate Bill 17? Senator Merrifield.
Thank you, Madam Chair. I did some research over the weekend, picked up some information and data from the Violence Policy Center concerning shootings that were perpetuated by individuals who did not have a concealed carry permit in states that don't require it, and in addition to some states that have some regulations. So what I found was 662 gun violence incidents in 39 states and the District of Columbia, resulting in 849 deaths, and in 85% of the incidents, 565 total, the concealed carry killer committed suicide. 293 has already been convicted, 204, perpetuated a murder-suicide, 51, or was killed in the incident, 17. Of the 76 cases still pending, the vast majority, 66, of the concealed carry killers have been charged with criminal homicide. 4 were deemed incompetent to stand trial, and 6 incidents are still under investigation. An additional 21 incidents were fatal, unintentional shootings involving the gun of the concealed handgun permit holder. 17 of the victims were law enforcement officers. 29 of the incidents were mass shootings, resulting in the deaths of 139 victims. The contention of the sponsor of the bill is this: if this legislation is passed, we will have a safer state. But the data and the facts show that is absolutely untrue. I urge you to vote no on this bill.
Senator Newell.
Thank you, Madam Chair. I rise in opposition to Senate Bill 17. And literally just a few moments ago, I had 2 constituents who were outside in the lobby who came to me begging me, literally, to vote against this bill. Both parents, both living in my district, and in my district I need to make sure you understand where I live is about 1.5 miles from Columbine High School, about 2 miles from Arapahoe High School, and about 3.5 miles from the Aurora Theater, where a devastating shooting happened. So in my community, firearms have been up front and center when it comes to the topics that constituents talk about and ask me about, and how to give me opinions on how they would like to see me vote. So I wanted to make sure that the people, I know that I am not the only one with constituents who are part of a community neighborhood grassroots organization called Moms Demand Action, and that's what they were doing. They were coming down today at the Capitol and talking about that. And they wanted to make sure that we would not effectively dismantle Colorado's concealed carry permitting system, making it legal for dangerous, untrained people to carry hidden, loaded handguns throughout the state. That does not mean that everybody who carries a firearm is dangerous. I am not suggesting that at all. But we have created a system here that has been making a difference. Is it perfect? No. But I certainly don't see dismantling it altogether helping at all. The other thing that I wanted to mention is that my colleague from the Jefferson County part of Littleton mentioned that it was a God-given right, that having a firearm was a God-given right. I would like to see where that is in any form of religious document where that is a God-given right. My God is a peaceful God. My God hasn't given me any messages about you must own or you can own a firearm, or that you can own a firearm no matter what regulations are within your community or your state. And so I'd just like to make sure that we're talking factually here and that we are talking about constituent opinions here and that we might be talking about our individual opinions here. But a God-given right is not one of those issues that, or one of those opinions that makes sense with this issue. I will continue to stand with my peaceful God and a nonviolent God, and so I vote no on Senate Bill 17.
Senator Neville.
Thank you, Madam Chair. This isn't a debate about what kind of God we have, because I believe we all have the same God. We're all created equally in His eyes. And it's extremely important to understand that God is a peaceful God, but God also wants us to be able to protect ourselves and our families, and understands that. And that is what the Second Amendment is about, friends. If we understand our constitutional rights are not given by man, as possibly my colleague from Littleton may believe, they are not given by man. They are granted by God. Certain inalienable rights, life, liberty, pursuit of happiness, property, those are things that are not to be taken away from us. And I remind you folks, I went through this personally, up front. My youngest son, most of you know him now as Representative Patrick Neville, who serves in the State House, was at Columbine that day. We made those trips to those people who lost, to those families who lost kids. We understand this. We also understand the need that for government to never, ever get in the way of someone being able to protect those they love and cherish. Again, I renew my call for you to vote aye on this bill.
Senator Lundberg.
Thank you, Madam Chair. This issue does have to do with safety. It has to do with peaceful coexistence with others. It has to do with the reality of how that is obtained. I'm quite grateful that there is a concealed carry system allowed in the state of Colorado. This bill, however, takes it the next step and says, but we don't need all of these regulatory hoops. I wish that on the day of the Columbine shooting that there had been the ability of somebody to defend themselves, but there was no concealed carry law at all in the state of Colorado. It was, well, statewide. it was conducted on a county-by-county basis. As a matter of fact, on that very same day, this body, this Senate body, was voting on a concealed carry bill. I know that because I was sitting right up there and I was listening to the vote. It was too little too late. This bill allows citizens to protect themselves and their families without undue government interference. This policy is not unusual to other states. Several states have implemented this bill, and we have not seen any dire consequences. And you know, the difficult thing there it is to get your arms around what effect a legislation like this would have is you don't hear all the stories, would-be tragedies that never occurred, either because there was somebody there to defend themselves and their family. I wholeheartedly support this bill. I trust that it will become law this year, but whether or not it survives the entire gauntlet of legislation this year, I am confident it will become law in Colorado. If you want to look at some statistics, look at how many states, let's go back to 2001. Very few states allowed concealed carry in much manner at all then. But the movement, you might say the arc of justice, has been moving towards allowing the citizens in this great nation to defend themselves in troubled times. And there are some troubled times and some troubled folks out there. I, for one, believe that the people of Colorado need to have the ability to step up and defend themselves, to step up and defend their families. This bill does more of that. It is a good bill. I urge its adoption. Thank you, Madam Chair.
Is there Senator Kerr?
Thank you, Madam Chair. I think what we just recently heard was what is often called the good guy with a gun theory idea, which from the information I've seen and people I've talked to, really just looking at the huge number of gun incidents around our country, and whether they are in concealed carry states or not, the number of, and as this bill is very broad. It includes schools. If you read the title of Section 2, right at the top of page 3 there, you see that it very specifically talks about schools, colleges, and university grounds. And if this bill is going to pass this body today, or someday, if we continue having this discussion on this bill, maybe for a fourth or fifth day, but if this bill is going to pass this body at some point, I'd like it to at least be limited and to take out schools. So with that.
Thank you, Mr. Majors. There is an amendment on the desk. Sorry, Senator Kerr. Mr. Majors, there is an amendment on the desk. Would you please read it? L003.
Amendment 003 to Senate Bill 17 by Senator Kerr, amend printed bill.
Senator Kerr.
Thank you, Madam Chair. I move L003 and ask for its adoption.
If there's no division, no problem. Is there discussion?
Is there any discussion on amendment L003? Senator Neville.
Thank you, Madam Chair. Give me a moment here to look at what we have.
We need them.
Okay, well,
Take 5. He needs more.
it is right until somebody says something.
Okay.
It's probably got
Friends, what we see here on this amendment is setting a standard that if you have the ability to carry a concealed firearm, you would not be able to carry it on a campus, on a college campus. I think we had that debate back in 2013, and I think it was such an egregious idea that it was actually withdrawn by my colleagues on the other side of the aisle. I urge a no vote.
Is there any further discussion on Amendment 3? Senator Kerr?
Thank you, Madam Chair. So again, I point you to the title of the section that is talking about schools, and we're talking about the safety of schools, the safety of students and teachers in our state. Let's at least compromise on this one provision, this one place throughout our state, and talk about whether or not we want people to have the ability to walk onto any campus, as it says there, a campus, where our students and our teachers, our professors are working, and try and carve out a little space in our state that isn't subject to the overreach that this bill is about. I ask for an aye vote on L003.
Senator Holbert? Okay.
Thank you, Madam Chair. I note in the title of the bill that it says, and in connection therewith, preserving current laws restricting the carry of concealed handguns on certain property, including school grounds. Now, this specifically is, I think, directed toward the prohibition of a permit holder carrying on a public K through 12 campus. But I think it's worth noting that this amendment seeks to prohibit it on college campuses. And it seems that we are extending beyond the preserving current laws. I won't ask for a title ruling, but let's keep in mind that adults, people who are 21 or older, who qualify for a permit, are currently allowed to carry on a public campus of a higher institution of higher education, our public colleges and universities. That has been settled by court. That has certainly been settled in statute, and I would ask for a no vote on the amendment.
Is there any further discussion on Amendment L003? The motion before the body is the adoption of Amendment 3. All those in favor say aye. Aye. Those opposed, no? No. The noes have it, and the amendment fails. To the bill, Senator Neville. Huh? Did I call him Mr.? Senator Kerr?
Thank you, Madam Chair. So as we've been debating this bill, I know that we've had quite a gathering out in our lobby of folks who are not in favor of the bill. I know that people who've reached out to me overwhelmingly have been against this bill. And so what I want to ask the bill sponsors, who exactly is in support of this bill?
Is there any further discussion on Senate Bill 17? Senator Kerr.
Thank you, Madam Chair. Well, since we don't have an answer to who is actually in support of this bill, I'm wondering if anyone other than 18 people I can think of are actually in support of this bill. So something else I noticed about this bill is that it was one of the very few that have come from one side of the chamber that has a safety clause on it. And it seems to me a safety clause, I've been told many times in my 10 years down here, safety clause is to try and get a bill enacted right away. It's very specifically does not have a petition clause in it. So since I can't find people who actually support this bill, we haven't been told of anyone who supports this bill, let's have the people of Colorado actually weigh in on this. I've heard that this is a new political tactic in our country, that if we don't trust the current President of the United States to appoint a Supreme Court justice during his term, but we're going to let the people of our country vote on who gets to appoint.
Senator Kerr, you move the amendment. Senator Kerr.
Thank you, Madam Chair. I think we need to be told that there's an amendment on the desk, and I'd be happy to move it.
Thank you. There is an amendment on the desk. Mr. Majors, would you please read Amendment 4?
Amendment L004.
Senator Kerr.
Thank you, Madam Chair. I move Amendment L004.
Thank you. Is there any discussion on Amendment 4? Senator Kerr.
Thank you, Madam Chair. So since we have been told that the people of our country get to vote on who becomes the next Supreme Court Justice of the United States, I think it's only fair that the people of Colorado should get to vote if this bill were to pass, this chamber, the other chamber, and get signed into law by the governor, that we have a petition clause that makes sure that the people of Colorado have the right to vote on whether or not they want this bill or not. That's what the petition clause does. So I ask for support of L004 because it allows the people of Colorado to decide if this is a bill that they want in law or not.
Senator Lundberg. Neville. Senator Neville.
Thank you, Madam Chair. And I would like to address the good senator from Jefferson County's first question. Yeah, there's somebody that's pretty important that is very, very concerned about the safety of everyone out there. And it's called our county sheriffs. And the county sheriffs support this bill, along with some other people too. So, but to address the good senator's question regarding why the safety clause, let me read the safety clause. The General Assembly hereby finds, determines, and declares that this act is necessary for the immediate preservation of the public peace, health, and safety. If any time a bill fits under the safety clause, and I don't often find a situation where they do, I believe this is one. I urge a no vote.
Is there any further discussion on Amendment 4? Senator Kerr.
Thank you, Madam Chair. So I believe the safety clause, probably most members of this body have it memorized. It's pretty short to the point. But let me read the petition clause. This act takes effect August 10th, 2016, except that if a referendum petition is filed pursuant, let me skip over a little bit. And this part will not take effect unless approved by the people at the general election to be held November 2016. And that's the important part there, unless approved by the people at the general election. If this is so important, let's let the people of Colorado vote on it. Let's let them decide on it. It's in our Constitution. It's one of the two choices we have at the bottom of every single one of our bills. Most of the bills that leave this chamber have that petition clause at the bottom. Let's make sure the people of Colorado have that voice. Please vote for L004.
Is there any further discussion on Amendment 4? The motion before the body is the adoption of Amendment 4. All those in favor say aye. Aye. Opposed, no? No. The noes have it, and the amendment fails. To the bill, Senator Neville.
Thank you, Madam Chair. Again, I urge passage of Senate Bill 17. Urge your aye vote.
Is there any further discussion on Senate Bill 17? Seeing none, the motion before the body is the adoption of Senate Bill 17. All those in favor say aye. Aye. Those opposed, no? No. The ayes have it, and the bill passes. Mr. Majors, would you please read the title of Senate Bill 34?
Senate Bill 34 by Senator Sonnenberg concerning tampering with a deceased human body.
Sorry. Okay, thank you.
Oh, Jerry?
Majority Leader Scheffel.
Thank you, Madam Chair. Oh, did it work out? It did work out. Thank you, Madam Chair. I move that the committee lay over Senate Bill 34 to February 23rd.
Motion before the body is to lay over Senate Bill 34 to February 25?
23rd.
23, thank you. All those in favor say aye. Aye. Opposed, no. The ayes have it. Senate Bill 34 is laid over to February 23. Majority Leader Scheffel.
Thank you, Madam Chair. I move the committee rise and report.
The motion before the body is to rise and report. All those in favor say aye. Aye. Opposed, no. The ayes have it. The committee will rise and report.
The Senate will come back to order. Senator Woods.
Thank you, Mr. President. The committee has met and had a number of bills under consideration. Mr. Majors, would you please read the report?
February 22nd, 2016, Mr. President, your committee told the report as it had on consideration the following tax bills being second reading thereof makes following recommendations are on Senate Bill 48, Senate Bill 17 is amended, passed the second reading in order and gross pace the calendar for third reading and final passage. Senate Bill 34 is amended laid over until February 23rd, 2016, and retaining its place on the calendar.
Senator Woods.
Thank you, Mr. President. I move for the adoption of the report.
You've heard the motion. Is there further discussion? Seeing none, are there any no votes? With 34 ayes, 0 noes, 0 absent, 1 excused, the report of the Committee of the Whole is adopted. Senate Bill 48, Senate Bill 17 as amended passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. Senate Bill 34 as amended laid over until February 23rd and retaining its place on the calendar. Consideration of memorials. Mr. Majors, would you please read the titles of Senate Joint Memorial 4?
Senate Joint Memorial 4 by Senator Martinez, Committee Representative Primavera concerning the reauthorization of the Federal Older Americans Act of 1965.
Senator Martinez-Humenick.
Thank you, Mr. President. I move Senate Joint Memorial 004 for favorable approval. And this is concerning the reauthorization of the Federal Older Americans Act of 1965. Colleagues, Colorado aging adults are being shortchanged in favor of aging adults in other states. You received a packet of information on your desk this morning. The map that you see that is in colored, Colorado is one of the red states, and we are being shortchanged monies that we should be getting for our seniors and our older Americans here, our older Coloradoans here. Colorado is number 3 in growth rates for the over 65 population, only behind Alaska and Nevada. So this is very important to pass today. Also, you should have a letter to the Congress from the Congress of the United States that is signed by Representative Mike Kaufman, Representative Ken Buck, Representative Diana DeGette, Representative Doug Lamborn, Representative Ed Perlmutter, Representative Jared Polis, and Representative Scott Tipton in favor of this Older Americans Act reauthorization. The hold harmless provision protects states that are growing older at a rate below the national average, and it really does harm states like Colorado that are growing at a rate faster than the national average. Colorado's older population has been growing at the 4th fastest rate in the nation, and according to the state demographer, by 2030, Colorado's population 65 plus will be 125% larger than it was in 2010. growing from 555,000 to over 1 million. I would ask and urge you to support this. It is important, and it is an important demonstration to Congress of Colorado's strong support for our older Americans reauthorization and to make sure that our older adults are being treated fairly along with other states. And right now, Coloradoans are not. So I would urge an aye vote.
Is there further discussion? Seeing none, are there any no votes? Recusing or no? Senator Lundberg. With 33 ayes, 1 no, 0 absent, 1 excused, Senate Joint Memorial 4 is adopted. Co-sponsors: Senator Crowder, Senator Hodge, Senator Jones, Senator Aguilar, Senator Cook, Senator Newell, Senator Kerr, Senator Roberts, Senator Carroll, Senator Merrifield, Senator Todd, Senator Holbert, Senator Woods, Senator Grantham, Senator John, Senator Kafalis, Senator Garcia, Senator Stedman, Senator Scheffel, Senator Baumgardner, please have the President. Announcements. Senator Newell.
Thank you, Mr. President. Members, you received on your desks this morning a little pot with seedling, and I am told it is a money tree. So make sure to take that to your office or to your home so it can start growing before the budget season is upon us. But seriously, the Junior League has given that to you today. The Junior League is having its Capital Day tomorrow, and plan that when you're coming in from a drive in the snow, that between 7:30 and 9 a.m. tomorrow morning outside of the old Supreme Court chambers, they are hosting their legislative breakfast. And they will have coffee and breakfast snacks. And you will also be able to learn about the initiatives that the Junior League of Denver is doing. And I think you will all be interested and probably welcoming a great cup of coffee. So see you in the morning, tomorrow morning, 7:30 to 9 outside the old Supreme Court chambers. Thank you.
Senator Todd.
Thank you, Mr. President, and I would like to encourage you to join us at the Celebration of Inclusion Colorado, the Sandpiper Awards. You saw this on your desk this morning, probably amongst many other papers, but this is going to be held at the Ralph Carr Center, and it is to honor former Governor Ralph Carr as well as our own Governor John Hickenlooper. So that is Wednesday the 24th at 4:30 to 5:30, so come and join.
Senator Lundberg.
Thank you, Mr. President. Members, all committees will be meeting as scheduled. However, State Affairs will not be hearing Senate Bill 38.
Senator Woods.
Thank you, Mr. President. I ask for a moment of personal privilege.
Granted.
Thank you. Colleagues, on behalf of myself and my office, I'd like to extend our condolences this morning to the loved ones of Major John K. Wells, a decorated Marine and an American hero. In the spring of 1945, Major Wells was a first lieutenant fighting in the 5th Marine Division on Iwo Jima. In complete disregard for his own life and safety, he gathered a group of Marines and led the charge up Mount Suribachi, eventually raising the first American flag on the summit. For his heroism, he was awarded the Navy Cross, the Bronze Star, and the Purple Heart. Major Wells truly embodied sacrifice, courage, and honor. Major Wells passed away earlier this month in Arvada at the age of 94, and while our community and his family are suffering a loss, heaven has gained an American hero. Today, let us all remember all of the members of this group we call the greatest generation. The morals they displayed, the lessons they taught, and the sacrifices they made in defense of liberty have defined our country and our freedoms down through the decades that have followed their service. We owe these brave soldiers a debt we can never repay. Thank you, colleagues.
Thank you, Senator Woods. Further announcements? Mr. Majority Leader.
Thank you, Mr. President. At this time, I move that the Senate adjourn to 9 a.m. Tuesday, February 23rd.
You have heard the motion. All those in favor say aye. Aye. Opposed, no. The ayes have it, and the Senate will stand adjourned until 9 a.m. Tuesday, February 23rd.